Good morning, everyone. With permission of the Learned Director, I would now like to begin today's session on Deliberation on Execution of Decrees and Orders and Sale of Movable and Immovable Property. To conduct the session, we have Honorable Mr. Justice Arindam Sinha, High Court of Orissa, as a resource person. May I now request Learned Director to kindly welcome His Lordship by offering khala and memento. Thank you very much, sir. I now request Learned Director to kindly welcome all the learned participants for today's session and further request Learned Director to please read the profile of His Lordship.
Good morning to all. It is a proud moment to acknowledge that we have a resource person from Hon'ble High Court of Orissa, Honorable Mr. Justice Arindam Sinha, Judge, High Court of Orissa. I, on behalf of Sikkim Judicial Academy, would like to extend warm welcome to His Lordship in this program. In fact, in spite of heavy pressure of engagement in discharge of divine function of justice dispensation system, His Lordship has been kind enough to take time, duly accepting our request and come all the way from state of Orissa High Court to bless all of us on the deliberation of this program. I once again welcome your Lordship, and we are privileged to have learned judicial officers from all districts and sub-divisional states who are present physically as well as through virtual mode. I, on behalf of Sikkim Judicial Academy, would like to extend cordial and affectionate welcome to all here in this program today. Now, without further delay, with prior permission, I would like to read out the profile of His Lordship in presence of all participating learned judicial officers. His Lordship was born on 2nd September 1965. His Lordship was enrolled as an advocate on 11th March 1991 and started practice for 12 years, principally before Hon'ble High Court of Calcutta. Practice in civil, commercial, arbitration and constitutional matter, but specialized in civil laws. Then His Lordship was elevated to the bench of Hon'ble High Court of Calcutta as an additional judge on 30th October 2013. Then His Lordship was appointed as permanent judge of Hon'ble High Court of Calcutta on 14th March 2016. Then transferred and took oath as a judge of Hon'ble High Court of Orissa on 8th October 2021. Now, with this brief sharing of His Lordship profile, now I would like to request His Lordship to kindly lead and guide us on the first session of today's program. Thank you.
I am very happy to be with you, and I hope that what I have to share with you, what I have prepared for you, will be of use to you. I was talking with your director, and he told me that so far as transfer of property is concerned, there are restrictions placed by local law. So therefore, that which goes on in the rest of India where restrictions are not in place, where people sue for an agreement to purchase property by specific performance, or they can do it straight away, or there is inheritance, or there is money decree on a mortgage for foreclosure. The execution of decree for the purpose of enforcement of a decree in respect of immovable property may not be of much relevance to you, because when I prepared to come and interact with you, I was not aware of this. This was an oversight on my part. So I made a general sort of investigation into the realm of execution, and I hope it will be of instruction to you. Now before that, let us have an introduction. Why don't we start with you?
Lordship, my name is Kisangchuki Barfunga, and I'm the Principal District Judge of Gangtok District and also in charge of Pakyong District.
Also Pakyong District.
Newly created.
I see. Right. Yes.
District Judge, Special Division 1, Gangtok.
I am SP Bhutia. At present, I am posted at Gazing as a district and session judge. I am also in charge of newly created Sorai district.
Civil Judge from Judicial Magistrate, Gangtok.
Lordship, I'm Charlie Sharma. I'm posted as Judicial Magistrate and Civil Judge of Gangtok and Sorai.
And do we have anyone else? They have also put up my note here so that they can follow it while I go along. Grab hold of a CPC so that we can refer to the provisions as we. You are all aware, are we ready? Yes. You are all aware that the Code of Civil Procedure provides for the procedure. There is the substantive part in the code, which are the sections. And the procedural part, the rules as to how to go about the procedure, is provided under the first schedule, the orders. Now, Order 21 in Code of Civil Procedure provides procedure for execution of decrees. Section 47 says, all questions relating to execution, discharge or satisfaction. These are the three things. Execution, discharge or satisfaction of the decree shall be determined by the executing court and not by separate suit. By amendment, purchaser of property at a sale in execution has been made deemed party to the suit in which the decree was passed. Let us look at section 47. You find that questions to be determined by the court executing decree. More important is explanation 2. The rest of it, this is the part that was put in. For the purposes of this section, a purchaser of property at a sale in execution of a decree shall be deemed to be a party to the suit in which the decree is passed. And all questions relating to the delivery or possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section. Now this was necessary because when in execution of a decree a property is sold, the purchaser is not a party. So if there is resistance upon the sale to a purchaser in a decree, the purchaser not being a party, how will it enforce obtaining possession of the property? All these questions gave rise to several conflicting decisions, which is why the purchaser in execution of a decree at a court sale was made to be deemed to be a party to the suit in which the decree was passed. Once we understand this, it will be easier to see later the significance of rules 97 and 99 in Order 21. Moving on, to remove general impression prevailing amongst litigant public that further and more difficulties await after getting the decree, to execute it, the legislature made drastic amendments in the rules of procedure to categorically declare that all questions, including questions relating to right, title or interest in the property on an application under Rule 97 or Rule 99 shall be determined by the executive court. Here it is to be noticed, Section 47 refers to all questions arising between parties to the suit or their representatives. Necessarily, disputes relating to right, title or interest in the suit property between parties to the suit or their representatives are to be and stand decided in the suit. Do you notice the distinction? Section 47 says all questions arising between parties to the suit or their representatives. Now, if plaintiff in the suit says that I have an agreement to purchase the suit property, I have paid the consideration to court, let the conveyance in respect of the property be executed in my favor, and he obtains a decree, then the decree needs to be executed. The person who is the owner of the property, who had agreed to sell the vendor, he has resigned from his agreement. That is why the court has stepped in and passed a decree for specific performance, specific delivery of the property. One of the requirements for the court is to see that the agreed consideration is paid by the plaintiff. Plaintiff puts in that money. Now, in execution of the decree, the property is to be given to the purchaser. Now, what does the court do in execution? The court, in place of the vendor, executes the document in favor of plaintiff. The conveyance is done. Now, the delivery of possession. The vendor is wrongfully sitting in the property. Now, when the vendor is sitting in the property, execution is confined to executing the decree. The decree says, upon the payment of consideration, the property must be handed over to the purchaser. So the executing court is to decide under Section 47 only questions relating to execution, discharge and satisfaction of the decree. Now here, the vendor cannot again raise a dispute on title. That stands decided in the suit. So the only questions that you can raise under Section 47 is the executability of the decree. You cannot go behind it. So you see, now, just to tell you in advance, what happens is sometimes the vendor puts in a third party to resist the execution. Now, if the vendor puts in a third party, that third party must necessarily claim under the vendor. Again cannot raise right title interest question. With vendor's right title interest already decided in suit. So you see, the only person who can raise a question of right title or interest in respect of the property which is against which the decree is to be executed has to be a third party not related to any party in the suit. We shall come to that. This is the distinction. 47 is only questions regarding executability of the decree. The Supreme Court in Rahul S. Shah versus Jinendra Kumar Gandhi, reported in 2021-6 SEC 418 in paragraphs 24 and 25. I have reproduced 24 and 25, said, now look at paragraph 24 in the judgment. In respect of execution of a decree, Section 47 of CPC contemplates adjudication of limited nature of issues relating to execution, that is discharge or satisfaction of the decree, and is aligned with the consequential provisions of Order 21. Section 47 is intended to prevent multiplicity of suits. It simply lays down the procedure and the form whereby the court reaches a decision. For the applicability of the section, two essential requisites have to be kept in mind. Firstly, the question must be one arising between the parties. And secondly, the dispute relates to the execution, discharge or satisfaction of the decree. Thus, the objective of section 47 is to prevent unwanted litigation and dispose of all objections as expeditiously as possible. Paragraph 25. These provisions contemplate that for execution of decrees, executing court must not go beyond the decree. Now it is not, the executing court must not be drawn into this inquiry beyond the decree, because it is not the appeal court. The learned advocates may want to draw the judge by raising a point which prima facie makes you feel probably the decree was wrong. But that is an area you should not tread as an executing court. Because whether the decree is right or wrong is to be tested in appeal, not in execution. Execution, the court's function is limited. The majesty of the court in having passed a decree must see execution. All frivolous objections must be thrown out. The judge must not be drawn into deliberation on very well presented arguments on merits of the suit. Do not go beyond the decree. However, there is a steady rise of proceedings akin to a retrial at the time of execution, causing failure of realization of fruits of decree and relief which the party seeks from the courts, despite there being a decree in their favor. Experience has shown that various objections are filed before the executing court and the decree holder is deprived of the fruits of the litigation, and the judgment debtor, in abuse of process of law, is allowed to benefit from the subject matter which he is not otherwise entitled to. Imagine the pain of this litigant who has obtained this judgment having gone to the Supreme Court. So, do not be misled or waylaid by apparently well presented arguments which will take you beyond the decree. Then we see the narrowing down. This then narrows down the scope under Rule 101 to admit such questions relating to right, title or interest in the property for adjudication as can be raised by third parties on applications under Rule 97 or Rule 99. Now these two rules are very important when you're dealing with execution as judges. Rule 97 provides for resistance or obstruction to possession of immovable property faced by decree holder purchaser. Purchaser is in the same position as a party in the suit, decree holder purchaser, in execution pursuant to a decree. So Rule 97 is the decree holder obtains assistance from court to go to the property, throw out the occupier and put him in possession. When the bailiff goes to the property, the court through the bailiff, when it goes to give possession, finds there is resistance. At that time, the decree holder or the purchaser in execution can file an application under Order 21, Rule 97, and go and tell the court, I need police help. The decree, there is resistance to execution, I need police help. That is 97. Be clear in your mind what is 97. For a moment, if you want, look at that provision. 2197. Have you got it? Resistance or obstruction to possession of immovable property. Where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person obtaining possession of the decree of the property, he may make an application to the court complaining of such resistance or obstruction. The decree holder or purchaser must make the application because he is facing the obstruction. Where any application is made under Sub-Rule 1, the court shall proceed to adjudicate upon the application in accordance with the provisions herein quoted. Very simple. The decree holder can come under 97. Be clear in your mind who can come under 97. So the only person or representative of such a person who can raise a question of right, title or interest in the suit property is someone apart or different from the judgment debtor or his representative. Under section 47, only executability. Because the question of right, title and interest has already been decided, because 47 is confined to parties or their representatives. 97, therefore, provides for those situations where apart from a party, someone else is resisting. Now, if that person is not a party to the suit, he will obviously say, I have right, title and interest in the property. And that was not decided in the suit. I was not party. So, no separate suit. 97. Now be clear. The decree holder goes to get the property. He is resisted by a person who says, I am claiming independently of defendant. I have my own right, title and interest in the property, which is why I shall resist execution. Only then the decree holder can go. Because if it is a purchaser, subsequent purchaser from the judgment debtor, if the judgment debtor, to avoid execution or having suffered the decree, a judgment debtor has suffered the decree, now he thinks the agreed consideration I will get from court. After having got it, let me sell it to a speculator for some more money, let me put him in possession. And he can drag the litigation and enjoy the property. If such kind of a person comes, a person who is a purchaser pendentiality of the suit, that person is claiming under the defendant, covered by 47, cannot come. He is not a person who resistance against whom the 97 application, when the decree holder makes, the right, title of question, if raised by such a person, the court will throw out. The 97 application will receive the order of police help on saying that you are claiming under the judgment debtor. You are purchaser from the judgment debtor. Therefore, you are covered by the decree. You cannot raise separately right title and interest question. So I direct police help, go and vacate the property, hand it over to the decree holder. This is 97. Rule 102 makes rules 98 and 100 inapplicable to transfers pending liability, what I was telling you. Let us look at Rule 98 and Rule 100. Rule 98. Order 21, Rule 98. Orders for adjudication. Upon the determination of the questions referred to in Rule 101, the court shall, in accordance with such determination and subject to the provisions of Sub-Rule 2, make an order allowing the application directing that the applicant be put in possession of the property or dismissing the application, pass such other order as in the circumstances of the case it may deem fit. Now Sub-Rule 2 of Rule 98. Where upon such determination the court is satisfied that the resistance or obstruction was occasioned without any just cause by the judgment debtor or by some other person at his instigation or on his behalf, or by any transferee where such transfer was made during the pendency of the suit or execution proceeding, it shall direct that the applicant be put in possession of the property, and where the applicant is still resisted or obstructed in obtaining possession, the court may also, at the instance of the applicant, order the judgment debtor or any person acting at his instigation or on his behalf to be detained in civil prison for a term which may extend to 30 days. So you're getting the clear distinction between a party or a person claiming under a party on one side and a third party, a genuine third party, who can say that I have a right, title and interest not decided because I was not a party. Only then there is going to be some determination. Otherwise Rule 98 applies. Look at 100. Order to be passed upon application complaining, we'll come to 100 a little later. We'll come to 100 a little later. I have already read for you under Sub-Rule 2. Then paragraph 4 in the note. Rule 99 makes it clear. Where any person other than the judgment debtor is dispossessed by decree holder, he can apply complaining of such dispossession and thereby raise for determination by the executing court questions relating to his right, title and interest in the property. Now what you must note here is, a third party, it must be, cannot claim under a party in the suit. A third party who stands dispossessed can come under 99. A third party in possession of the suit property cannot come under Rule 97. That is for the decree holder on facing resistance. 99 says only if the third party is dispossessed, he can come. So the third party cannot apply to the executing court and say, I am threatened with dispossession under execution. A lot of litigation happens on this apprehension. A party who is going to be dispossessed by execution of a decree applies to the court, executing court, and says, I am threatened with dispossession, please protect me. Order 21.
Sorry to interrupt, but
Yes.
just for clarification, so he has to go under 97 then, in that case?
That is what I am trying to tell you. 97 is for the decree holder.
And the third party,
Third party can only come after dispossession. He cannot come anticipating on apprehension of dispossession. This was done to expedite execution. Once the court has adjudicated and decided that a person is entitled to a property, he is to be put in possession. Now by that, if someone else is dispossessed, no separate suit lies. But in execution proceedings, it will be decided. If that third party is able to convince the court that he does have a right, title and interest, then restoration may follow. The executing court will restore possession to the third party. But the third party, to be able to apply to the execution court must first have been dispossessed. As judges do not allow persons who claim to be third parties to stall execution on their apprehension of being dispossessed. That's the idea. This is the expediting the execution. That's the whole purpose. Proceeding further.
Lordship, but then in that case, what happens to the poor decree holder?
No, decree holder, the court is acting in his assistance, in his favor. The decree holder, if he faces resistance, he applies under 97. The decree holder goes and gets the possession. The person who is dispossessed now can come under 99. But first he has to be dispossessed. He cannot come saying, I am threatened with dispossession. That's where execution gets stalled. Paragraph 5 of the note. It is important to remember that not all cases of resistance or complaints of dispossession necessarily require the executing court to adjudicate on questions of right, title or interest in the suit property, as those already stand decided in the suit. It is only when such questions arise at instance of a third party is the court required to adjudicate on such person's right, title and interest in the property on the person either resisting execution and decree holder applying, or the person complaining of having been dispossessed in execution. There is no other provision in Order 21. If you remember these two principal fundamental things of approach to executing court, you cannot go wrong. These two instances can arise only on the two circumstances provided by Rules 97 and 99. Now let us see what has happened. In a recent judgment dated 6 July 2022, just yesterday, sort of, in civil appeal number so-and-so, Shri Housing Finance Investment India Limited. Note the name of this party. Shri Housing Finance and Investment India Limited versus Umesh Mishra Memorial Charitable Trust. The Supreme Court found the facts briefly to be that settler of respondent trust was owner of the property. You do not worry about that. I'll ask the director to circulate my note to you. So you will get the citation and everything. You can keep this as a brief referencer as you go along. The Supreme Court found the facts briefly to be that settler of respondent trust was owner of the property. Let us understand the facts step by step. The owner of the property is the person who has created a trust. Settler. In ground floor of which he had inducted a tenant. So the settler is the original owner. The property as a whole has a ground floor in which the settler had inducted a tenant. The settler had two sons. So the father has created the trust. The father is the owner of the property. He has inducted a tenant in the ground floor. He has two sons. We are getting the facts. The younger son died and the trust was settled in his name. That is why the trust, the father remembers his younger son. So he creates the trust in the younger son's name. The settler had filed a suit for eviction against the tenant, and same was continued upon his death. The father died. By inter alia, the trust being added as party plaintiff. Because during the continuance of, he had filed the suit as owner, landlord, tenant, you get out. Now during the pendency of the suit, his son died. He has created the trust in name of his son, the deceased son. He dies. Now the heirs and legal representatives have applied to be substituted as plaintiffs. The trust also applies. The trust says, I am the owner of the property. The original owner had settled the trust on the property. So the trust is also added as party plaintiff. The trust continues the suit against the tenant. The suit was decreed and the trust filed for execution. When the execution court proceeded to execute the decree, appellant before the Supreme Court, again look at the appellant, Shri Housing Finance Limited. The page before, Shri Housing Finance and Investment India Limited, a finance company, a non-banking finance company. This is the appellant before the Supreme Court. Appellant before the Supreme Court, in resisting execution, filed a separate suit, claiming to be transferring in respect of the demise from the elder son, having obtained possession from the tenant. Now see, this man had two sons. The younger son died. The man creates a trust of the property in the name of the younger son. What does the elder son do? He takes loan from this finance company and says, my father has died, I am selling you the property. He first kept it as security for repayment of the loan, and then he said that you take the property. Now this finance company has obtained some sort of interest in the property from the elder son who had no authority. Goes to the tenant and throws her out and takes possession of the ground floor. Execution is being resisted by this finance company on the suit where the trust has obtained a decree. So see the situation that has developed. Now, appellant subsequently withdrew its suit. The finance company withdrew its suit and filed application in the execution proceeding for determination of its claim of right, title and interest in the demise. It is saying, I have got it from the elder son, who is the son of the owner of the property. I have a good right. This was not decided in the suit. I am a third party. So he came before the executing court. The Supreme Court held that appellant was neither decree holder facing resistance in execution, nor a person admittedly being in possession of the demise who could claim of having been dispossessed in execution. You see how it is becoming clear? Only two ways a person can resist execution of decree against an immovable property is for him or her to be a third party to the suit and resist where the decree holder applies under 97, or he is thrown out and then he comes under 99 for restoration. So if you follow the provisions regarding execution, there should be no difficulty in execution of decrees. If a suit takes 10 years, execution of decree should take 6 months. But sometimes execution proceedings outlive the tenure of the suit because of all these things that happen. Can you imagine what has happened here in these facts? Very rarely can a person be in possession of a property and claim right, title and interest in it as a third person. Very, very rarely. See, here also, Shriram Housing Finance cannot claim to be a third party. It is claiming under plaintiff's elder son, and a son is claiming under plaintiff, a party in the suit. So you see, in this connection, paragraph 32 to 34 from Rahul S. Saha, the first judgment that I had given you, are reproduced below as valuable instructions on the provisions. This is Supreme Court. While there may be genuine claims over the subject matter property, the court also recognizes that there might be frivolous or instigated claims to deprive the decree holder from availing the benefits of the decree. Sub-rule 2 of Rule 98 of Order 21, which I have already shown you, contemplates such situations and provides for penal consequences for resistance or obstruction occasioned without any just cause by the judgment debtor or by some other person at his instigation or on his behalf, or by the transferee, where such transfer was made during the pendency of the suit or execution proceedings. However, such acts of abuse of process of law are seldom brought to justice by sending the judgment debtor or any other person acting on his behalf to civil prison. In civil judges, they never invoke the provision to send anyone to civil prison. In criminal jurisprudence, you are very hesitant when you decide on the conviction and thereafter the punishment. In criminal trial, there is the first regarding conviction. On conviction, there is a separate hearing for the quantum of punishment. As judges, the approach is very hesitant to deal with and impinge on a person's liberty. You see, if you look at the capital punishment, what Supreme Court has laid down so many doctrines that have emanated from the Evidence Act. The last seen theory, these, that, so many things are there. Because the jurisprudence is, in criminal jurisprudence is innocent until proved guilty. So therefore the hesitance. So if in criminal matters there is so much hesitance, sending to prison in civil cases is unheard of, though the provision is there. I am not advocating that you should exercise your power to send somebody to prison on the civil side. But deal with execution without being drawn into unnecessary complications and legalities spun from the bar. And you see, because the most competent professional lawyer, it's his job to get some persuasion from the judge and some relief for his client. So don't hold it against the lawyer. If you know what is right and what is wrong, you have the pen. Ask the questions to clarify any doubt in your mind. There is also this thing which I must tell you. The better the lawyer, the better the court craft. Now, a good lawyer will intimidate the judge. That's also part of his court tactics. He will make you feel that the questions you are asking are foolish questions. That you, in asking those questions, reveal yourself to be an ignorant person. So the judge feels intimidated and doesn't ask the question that is there in his mind. Now this is the craft, court craft of a lawyer. And you cannot hold him in contempt or guilty for any misconduct in adopting those crafts. So you have two options. One is to have the confidence to tell the lawyer, I don't know. You're the learned lawyer. You tell me what the law is. And this is my question. That's your first option. Second option, read it up yourself. There cannot be a question in the realm of law, the answer to which you cannot find. Because progressing as a judge in matters legal, you cannot say that I must refer to Google or to somebody else for answer to a question I have. Law is a subject that makes you learn. Open the book and find the answer. We are dealing with human nature. All kinds of disputes have been decided. Look up the law. This is my advice to you as judges. Because you see, the public look up to court. And unless you have everything thrown at you, how will you be a good judge? So when you write a judgment, be brief, be to the point. Do not elaborate. You will not need to if you know the law. You need to elaborate when you're trying to explain something which you yourself don't understand. So if you know the law, it's very precise. You can, and there is no necessity at your stage to write a judgment that is going to be of instruction to somebody. Leave that to Supreme Court. Leave that to the Supreme Court. The Supreme Court writes judgments which are voluminous. They are the last word. Article 141 says the law declared by the Supreme Court is binding on all courts and tribunals in the territory of India. So leave that to the Supreme Court. If you do your job correctly, because you see, one of the best ways in writing a good judgment is to be brief. All you need to do is get your meaning across to the person who reads your judgment. Let me tell you, very few people will read your judgment. So there is no requirement to write a novel. Very few people. Who will read? The aggrieved lawyer. The aggrieved litigants lawyer will read. And the appeal court may read. No one else will read. Degree holder will judgment, the person who gets the judgment also will not. So do not go into essay writing in a judgment. Briefly, this is it, and this is my decision. Because at the level you are, there will be precedents shown to you. Very little scope of saying something original. Confine yourself to that, and your judgments will be confirmed. Let the higher courts elaborate. You do your job. You will be a good judicial officer. Alright? Let us go to the next paragraph in that judgment. Paragraph 33. This is that first Rahul S. Shah judgment. In relation to execution of a decree of possession of immovable property, it would be worthwhile to mention the twin objections which could be read. Whereas under Order 21 Rule 97, a decree holder can approach the court pointing out about the obstruction and required to pass an order to deal with the obstructions for executing a decree for delivering the possession of the property. The obstructionist can also similarly raise objections raising new issues which take considerable time for determination. Now this, of course, the Supreme Court has not gone on to say that this he can do only after being dispossessed. However, under Order Rule 99, it is a slightly better, now the Supreme Court is saying in the next paragraph. However, Order 21 Rule 99, it is a slightly better position, wherein a person other than a judgment debtor, when he is dispossessed of immovable property by the decree holder for possession of such property, files an application with objections. Such objections also lead to retrial. But as the objector is already dispossessed, the execution of the decree is more probable and expeditious. See the scheme. The scheme is the intent, the object of the law is a presumption that there cannot be a third party with a separate right, title and interest theory other than the persons to the suit. It can happen. There are collusive suits. There are collusive suits, especially in the realm of partition, where few of the family members file a collusive suit and they compromise and obtain a decree. And they want to execute the decree for the purpose of crystallizing their right, title and interest over joint property, leaving out other co-personers. So there can be situations where there are. But then if it is a collusive suit, then a good lawyer will find a way to file a separate suit. If it's a collusive suit, he will argue the decree is a nullity. Section 47. So you see, you must, if you are good judges, you will also encourage the bar to develop themselves. They will study hard and They will work to come and persuade you. It will be an interesting session where the argument is there from the bar and the bench decides. It's a wonderful thing we have got into. Next, purpose of the drastic amendments was for expeditious execution of decree in aid of a successful litigant who has obtained it in his suit by pleading and proof of his claim. On there being a decree for execution and no impediment by stay order from a higher court, the executing court must, with priority, ensure that the decree is executed, discharged and satisfied. In doing so, the executing court must focus on execution and not be drawn to go behind the decree. Exercise of powers under section 47 is microscopic and lies in a very narrow scope. Thus, it is plain that the executing court can allow objections under section 47 to the executability of the decree only if it is found that the same is void ab initio and null, apart from the ground that the decree is not capable of execution under law, either because the same was passed in ignorance of such a provision of law, or the law was promulgated making the decree inexecutable after its passing. Two situations. One is the judge executing court passed the trial court passed the decree unaware that there is a law which prohibits such a decree being passed, or rather which would make the decree inexecutable. So that would make the decree ab initio void, null. So that is a question that would come under 47. Or the decree has been passed today, tomorrow there comes a law which makes it inexecutable. That can also happen. Because it is the prerogative of the legislature. They have, over a period of time, there has been a lot of legislation. The code was comprehensive, there is a lot of amendments came to the Civil Procedure Code in 1976. Thereafter, there were some amendments in 1999 and given effect in 2002. Amendments happened. If you look at all of us are getting a salary from which tax is deducted. I have been told by your Chief Justice that Sikkimese people who earn in Sikkim are exempt from paying income tax. If you want to carry on with your careers and serve only in Sikkim, that's good for you. You'll have a lot of money as not having paid tax. But then you might also want to venture out and go and see what the situation is in other parts of the country. If you do that, on the one hand you'll be richer in experience, on the other hand you'll be poorer by paying tax. So, the law of tax, direct tax, income tax, it's really not a book. Every year, on the presentation of the budget, there is an amendment to the way in which the subjects are to be taxed. Because if you look at the concept, the government is your partner in profit. Whether you are doing business or you are in salary, in a job. If you are earning money, the government wants a share, partner in profit. If you are making a loss, that is also to an extent a profit, because in income tax law, the loss you suffer today, you can set off or adjust against your income of tomorrow. So in this financial year, if you have a loss, in the next financial year of income, you can set off the loss and reduce the amount of income on which you will pay tax. This is also the income tax law. So you see, it's a battle of wits. On the one hand, the businessman is trying to make his accounts such that he pays less tax. And on the other hand, the government is trying to make the net more complex so that the citizen cannot escape paying tax. So therefore, the income tax law develops every year. So, the amendment or a new law coming is a very real possibility. So today you pass a decree in accordance with law. Tomorrow there may be a law that doesn't allow the decree to be enforced. So that can happen. So that is a question that would arise in section 47. Because it's not to do with right, title or interest. It is to do with the executability of the decree. Then we come to paragraph 7. Substantive law procedure regarding execution is provided by several sections in the code, commencing with section 47 to section 74. Procedural provisions are in order 21, the longest order in first schedule of the code. There are 106 rules. Application for execution must be made by decree holder or his transferee. Who can apply for execution? Either decree holder or transferee. Transferee would include purchaser, who's made a party by section 47. So, application for execution must be made by decree holder or his transferee. The application must be against judgment debtor, or if he is no more, his legal representatives. So we start at the beginning. Who makes the application? Against whom is it to be made? Then, Rule 11 gives the requirements. If you look at Rule 11 in Order 21, it will give you the requirement. You have to give the requirements of assistance in a tabular form. That is what is required under Rule 11. What kind of assistance do you want? What is the description of the nature of the property against which you want this execution? It may be movable, it may be immovable. So there are these several tables, these particulars which have to be filled in like a table, and in support of which the person applying has to file an affidavit in support of the information given in a tabular form. So the decree holder transferee applies against judgment debtor or his representative in tabular form. We will come to three parts. Under Rule 21, now execution can be had against property of the judgment debtor or his person. Under Rule 21, the court may, in its discretion, refuse execution at the same time against the person and property of the judgment debtor. So far as an executing court is concerned, a person may apply to have both. I have got a decree for X amount of money from Y. A person can come to the executing court and say, you catch Y and force him to pay me my money either by attachment or by sale of his property. And you also direct that he go to prison unless he pays you. This is possible. So you can proceed against property as well as person. But Rule 21 says, look at 21. Order 21, Rule 21. Simultaneous execution. The court may, in its discretion, refuse execution at the same time against the person and property of the judgment. So this discretion is with you, because you can assess the situation. If you find that sending to prison may cause execution, you can direct that. Generally what happens is, first is to proceed against the property and then proceed against the person. I have just given it to you the other way around, but general approach is, you first, if there is for both, it is not that you cannot do both, but you have the discretion that let us try the property route. If it doesn't happen, or if there are no property, then we can go the prison route. Because sometimes to avoid execution, people file for bankruptcy. I do not have any property. Or they transfer out their properties. You see, many kinds of things happen. Litigants, they use their mind to get to avoid the rigors of the law, because it's a matter between two persons. One person is trying to say, I have this right over that person, and the other person is denying. So both are trying their best. Court is in the middle, and you have the law. All right. No, we have done this discussion. Next, page 8. The law does not require any notice to be issued to the parties against whom execution is applied for. This is very important. Except where the application is made more than 2 years after the date of decree, or more than 2 years after date of last order made on any previous application for execution. This is provided in Rule 22. Notice, however, is necessary where execution is applied for against legal representatives of the judgment debtor. There are other situations requiring notice provided by Rule 20. Also, where on a decree for payment of money, decree holder applies for execution by arrest and detention of judgment debtor, the court, instead of issuing a warrant, shall instead issue notice asking judgment debtor to show cause as to why he should not be committed to prison as provided in Rule 37. Now let us understand. A suit is presumed to be adjudicated on notice. There is an order, I think it's order 5, that deals with service of summons and substituted service. So when a court proceeds with adjudication of the suit, the first hurdle of satisfaction on service is obtained. A summons can be served, a summons can be avoided, a summons can be refused. There are situations where court can come to the conclusion that service is good. Only thereafter there is proceeding in suit. So if a person deliberately stays away from the adjudication, Order 9 provides for ex parte adjudication on the suit. So there can be a decree ex parte. Even then, once the premise is that there has been service, there is this 2-year window given for execution of the decree without requiring another procedure of serving fresh summons or notice. So first 2 years after decree passed, straight away the decree holder can apply without notice. Now where is notice necessary? The decree is passed after the date of decree but before 2 years. Judgment debtor dies. Now the decree holder wants to file for execution, having waited say 1 year and 6 months for the judgment debtor to comply, and there not being any compliance, decides to now file for execution. He finds judgment debtor has died. There he cannot proceed with the execution without notice, because there is someone else. So there is requirement to serve notice. Also, if the application for execution is only for the purpose against the person, send him to prison if he doesn't pay me. We know about Merchant of Venice, where Shylock asked for a pound of flesh. Either my money back or a pound of flesh. This is the person concept, where Portia said, all right, you take that pound, but you cannot shed a drop of blood. So you see, the law develops. This is the person concept. You send him to prison. Now, where a decree holder has applied before 2 years of the decree, after the decree, but wants execution by arrest, there, instead of the court straight away issuing the warrant, we'll give him a notice. Tell me why I should not send you to prison if you do not pay. So this is the provision regarding first who can file, against whom to be filed, and when you can file without notice, and what are the situations where notice is required. So it's very clear. As an executing court, if you find an application is there for execution within 2 years, but it is directed against persons who are not parties, you immediately know notices to go. Or if it's for person, you know that, let me give him an opportunity that I will arrest you unless you pay. Otherwise, no notice. It becomes very simple. You have to understand, if you understand the law, these 106 rules in Order 21 should not get you down. It's so many decisions on so many rules, no problem at all. Just get the concept, the underlying object, expeditious execution of the decree. Next, paragraph 10. Execution against property of judgment debtor may be considered under two heads, namely attachment and sale. Attachment can be of movable or immovable property. In case movable property attached is subject to speedy and natural decay or deterioration, it must be sold forthwith as provided in Rule 43. The rules go on to provide for sale of attached property and setting aside of sale if the court is satisfied that party seeking to set it aside has sustained substantive injury by reason of irregularity or fraud as provided in Rule 19. This can happen. There can be a court sale, there can be confirmation of sale, and thereafter somebody comes and says, set aside the sale. So the question on a setting aside of sale must be irregularity or fraud. Irregularity how? Because there must be proclamation of sale. The sale must be widely advertised. There are procedures for it. Now, if that has not been followed, it would be an irregularity. And if there is an element of practice of fraud, then the fraud unravels all. So once the court is convinced that there has been practice of fraud, set aside the sale. It can be done again. But the presumption is what is done is duly done. After all, court has a mind. Court does not act mechanically. So, even where there are applications for setting aside sale, be very careful. Next, decrees are not only against property, movable and immovable. Decrees can also be for specific performance or for injunction. Those decrees can also be enforced in execution by attachment of property. While a decree for restitution of conjugal rights can only be executed by attachment of property, decrees for specific performance or injunction can be enforced by attachment of property or by detention in civil prison or by both. Rule 32. Rule 33 provides for discretion of court regarding enforcing a decree for restitution of conjugal rights. Now I want that all of you look at Rule 32 and tell me, am I correct in having made a distinction between the execution of decree for restitution of conjugal rights to be only executed by attachment of property and not by sending to civil prison? 32.
If you send the person against whom the restitution of conjugal rights has been claimed and you send that person to prison, then the whole object of restitution
You are giving the first response that has come to your mind. Look at Rule 32. Sub-Rule 1. Rule 32, Sub-Rule 1. Look at it and tell me, can restitution of conjugal rights be enforced by sending to civil prison? Yes?
Also, I think nowadays, institution of conjugal rights cannot be enforced.
Your audio is not clear. What are you saying? Once again, somebody will be able to understand and tell me. Read that provision. I am trying to also initiate you into reading of the statute and interpretation of statute.
Lordship, 32(1) gives a discretion to the court because the person has the opportunity of obeying the court's orders.
Yes.
So,
But my question is, a person, either the husband or the wife, has got a decree for restitution of conjugal rights. The other person doesn't want to stay together. Now, remedy in execution, so far as restitution decree is concerned, is only by attachment of the defaulting party's property and not by sending that defaulting party to prison. Am I right? Look at that provision. Yes? Am I right? Why am I right? Tell me. Use the mic. Tell everybody. Put it on.
Lordship, I think these days,
Yes?
Restitution of conjugal rights is not enforced by the courts.
Yes. Why do you say so? Why do you say so? On reading of Order 32, Order 21, Rule 32, Sub-Rule 1, why do you say so? Explain it to all of us. You want to attempt an explanation? You want to attempt an explanation? No. Who wants to attempt an explanation? Reading and understanding a statute as a judge is very important. Misunderstanding will lead to error.
Lordship, you
Yes?
cannot force a person to live with somebody against his will. So if he has opted not to obey the court's orders for restitution, then the court cannot force him. So there is an option, discretion here given to the court, either by attachment of his property or civil prison or both. So you should go for the, not for the...
No, my interpretation of this sub-rule is,
you should attach the property.
regarding restitution of conjugal rights decree, you can only attach property, you cannot send to jail.
But Lordship, the provision provides for both.
That is why I am asking, am I right in my interpretation?
Yes,
You think
Lordship,
I am
because
wrong?
you cannot, no Lordship, because you cannot force a person to live with somebody against
Does
his
the rule provide that you can send to prison?
No.
The rule provides you can send to prison.
Rule provides you can send to prison. So therefore my
It's your interpretation because you have a
construction
discretion.
according to you is wrong. Yes?
No, Lordship, because I think your interpretation is right, Lordship, because here in the rule it specifically says, has willfully failed to obey, the decree may be enforced, in bracket 1, in the case of decree for restitution of conjugal rights by attachment of property, or in the case of decree of specific performance.
You are not reading the rule. You are reading a note
No, Lordship, Rule 1, Order 32, Rule 1.
from the
Subclause
book.
1. Yes, Lordship. Subclause 1.
You read it from the text.
This is the text only, Lordship. Just taken as.
See whether this text is the same thing. You are reading an annotation. You are reading a judgment annotation.
Lordship, the Rule 32
32.
only states that property can be attached.
Yes?
Rule 32 only states that property can be attached in a decree for restitution of conjugal rights.
You get the difference. You are reading the notes on cases, not the rule itself. So we have one answer, that I am wrong, and I don't find anybody saying that I am right. Yes?
I didn't say your lordship was wrong, lordship.
Why not?
Interpretation.
Why not? I can be wrong. You see.
No, lordship, I was just saying that you can use your discretion.
All right, I'm putting it simply, right and wrong. You haven't said it. The thing is, you as judges also, you must remember to be able to tolerate the appeal court. Because when you write a judgment and the appeal court sets it aside, be tolerant of the appeal court. Do not be angry. Because, you see, there is no absolute truth. You have taken a view. You thought is the correct view on what you saw before you. The matter goes to the appeal court takes a different view and says you are wrong. That is because the appeal court is a higher court. I am not saying the appeal court is a better court. It is a higher court. So the appeal court may say you are wrong. Be tolerant of the appeal court. Now the appeal court's view is tested before the Supreme Court. The Supreme Court says you are right. The appeal court was wrong. That's still a view. It may be a declaration of law because it's by Supreme Court, but it's still a view. Supreme Court constitutes larger benches to overturn their own judgments. So the argument continues. There is no absolute truth. So say with boldness that I am wrong. Yes, let us read the provision.
May I?
Yes.
In Section 32, Clause 1, there's a two parts. One part is so far as restitution of conjugal right, only attachment. You cannot send the civil imprisonment. So far as decree for specific purpose of contract or for injunction, in that aspect, you can send in civil imprisonment or attachment property.
Your colleague or your senior colleague has got the answer. Because there is two parts to that sub-rule. Separated by the disjunctive or. So, for restitution of conjugal rights, this rule, sub-rule, only authorizes attachment. But, for the other, attachment and civil prison. So, this is an exercise in interpreting the statute. The disjunctive or is there, it separates and therefore makes restitution of conjugal rights available by execution only through attachment and not by civil prison. The logic both of you gave is correct. You cannot really force somebody. Because the Hindu Marriage Act provides that where there has been a decree for restitution of conjugal rights and there is violation of the decree, that can be a ground for divorce. So, another basic principle you must remember as judges is, there cannot be a situation where a person is remediless. Now, one person has got a decree for restitution of conjugal rights and is unable to enforce it. Does he or she become remediless? The law does not contemplate that in the arena of disputes, a person should be rendered remediless. You see, in the construction of the Civil Procedure Code, appeals are provided. But where there is no appeal, there is revision. The basic concept is, you cannot create a situation whereby a person is rendered remediless. That is a very basic principle of law. If you understand the concepts, you will have no problem at all. Because when you are writing a judgment, if you find that your judgment is leading to a situation where a person is being rendered remedialess. Because either there is no appeal provided from your judgment, or for whatever reason, then you might make an inquiry before you sign the judgment as to am I doing the right thing. But if you find that you are getting into a situation where you are writing a judgment from where no appeal is provided, do not discount the fact that a revision is possible. 227 is possible under the writ jurisdiction. From your judgments, 227 also happens, because now the general trend is nobody goes under section 115A. Everybody applies to the writ court, to the High Court, that this court has acted with illegality, has acted with material irregularity, therefore you interfere and do something about it. Right? So, shall we break now and come back after lunch? And after I take you through my note, whatever little left is left, we will then have interaction, and you can ask me questions, and I will also ask you questions if necessary. Not only confined to execution. We can broaden the discussion part of our participation to any questions that you might have. And if I don't know the answer, we'll find it together. All right? We come back after lunch? This has been a very good experience for me, because as a judge I am used to listening. You've given me an opportunity to say something. Yes? It's been a long time since I said something, because I was in the bar, and one of the things about being a good lawyer is also to allow the other guy to win your case for you by saying that which is unnecessary. It's not always required to say so many things. So always look for that lawyer who doesn't say too many things. You'll know that that guy's got a case. Alright. Sure, we'll come back after lunch. Shall we resume? We were at paragraph 12 of my note. Before that, just let me quickly have a look at. We are at paragraph 12 of my note. 12. Rule 34 provides for enforcing decrees for execution of documents or endorsement of negotiable instruments. Execution of documents would include a decree where there is a decree for specific performance, and on an agreement where a person has agreed to purchase another's property. Now, the vendor refuses to abide by the agreement, and that is why the suit for specific performance. Digressing here a little bit, just want to let you know that the general remedy for enforcement of contracts is to sue for damages. A and B enter into a contract for anything. The general remedy is for breach of contract and damages as assessed by section 73 in Contract Act. There may be also liquidated damages where at the time of entering into an agreement, parties decide that if there is a breach, then the damage at the time of execution of the agreement, they quantify the damage. That is called liquidated damages. Because the parties agree that consequence of breach will lead to this amount of damages, it is a liquidated or a crystallized sum of damages. Otherwise, damages need to be proved by loss suffered for the purpose of a decree of damages as compensation for the loss suffered. Now, the specific relief act provides for an exception to the usual law that breach of contract has remedying damages. Only in respect of the specific relief act, in respect of immovable property, there is the provision to specifically enforce the contract against the defaulting party. Now the vendor says, I will not execute the conveyance. So that the plaintiff says, execute the conveyance. So the first sentence in paragraph 12, Rule 34 provides for enforcing decrees for execution of documents. Would mean where a plaintiff is asking for execution of, say, a conveyance or endorsement of a negotiable instruments. Instruments are negotiable. You may have a bill, a party may have a bill payable by someone. The party might endorse the right to receive under the bill to someone else. The bill being an instrument, it becomes negotiable. A person is a holder of a document which entitles him to some consideration. He may sell that document or transfer that, negotiate that document by endorsing someone else's name to be the beneficiary under that document. That's the negotiation bit. So, either for the purpose of execution or for the purpose of negotiating an instrument, negotiable instrument, the court becomes the person who does it for the defaulting party. So A has agreed to buy from B. A succeeds in the suit, saying that this is an agreement, it was duly executed between the parties. The agreement was for X amount of consideration for the purpose of sale of B's property to me. I have paid the consideration. Now I want execution of the document in relation to the property and possession. Or if I am already in possession, I only want execution of the document, because that will become my title document. I will register it and perfect my title over the property. So this the vendor is not doing. The court then executes the document on behalf of the vendor. So also in case of an instrument that is to be negotiated, the court makes the endorsement. This is that rule. Rule 34 provides for enforcing decrees for execution of documents or endorsement of negotiable instruments. There is procedure provided for the court to execute the document, to have same effect as execution of the document or endorsement of the negotiable instrument as done by the party ordered to execute the document or endorse the negotiable instrument. So the court does it. The court through its office does it. So the person who gets a decree, a conveyance executed by the court in respect of a property, pursuant to execution in a decree, has a good document, can register it, and thereafter based on that document deal with his property. Might mortgage it, might sell it, whatever it is. Next 31. Rule 41 provides for examination of judgment debtors as to their property. The executing court can require judgment debtor to file affidavit of assets. There is power of court to direct detention in civil prison on judgment debtor disobeying direction of court to render affidavit evidence of his assets. So this is also a step taken in execution. Because plaintiff, having obtained a money decree, it would be wrong on the part of the court to tell the plaintiff to file affidavit of assets of judgment debtor. Plaintiff will not know. Plaintiff has entered into a transaction where the judgment debtor is trying to dupe him. So it is unlikely that where the judgment debtor has kept his property, plaintiff will know. Order 41 really empowers the court to go after the judgment debtor. You are the one who has to satisfy the decree. You tell me where your property is, because you are not yourself voluntarily paying up. So I want particulars of your property because I will move against them in executing the decree. So the affidavit of assets to be called for by you as executing courts must be from the judgment debtor. It is wrong to compel or require the decree holder to be able to come up with affidavit of assets of his opponent. He is unlikely to know. The judgment debtor himself will try to avoid giving particulars of his assets. He will try to deal with his assets in the meantime to avoid execution. So if he has not given a correct picture of the assets, or correct affidavit of his assets, he will be guilty of perjury. He will be guilty of, in addition, straight away being sent to civil prison. Alright. Then we come to paragraph 14. Garnishee proceedings are also provided for in Order 21. It is simply that where a person owes a debt to judgment debtor, and the debt has been attached in execution, the court may give a notice to the debtor as to why said person should not pay the debt in court against execution of the decree. On payment by the debtor, there will be valid discharge to him against the judgment debtor. Execution can also be by attachment of salary, partnership property, or property of the corporation. We will come to that later. First, garnishee proceedings. A enters into a transaction, A lends B money. B does not repay. A files a suit for recovery of money. I am just giving an example. Unregulated lending money is prohibited in law. The business of lending is regulated by law to be conducted by banks and non-banking financial institutions under the guidelines of the Reserve Bank of India. But there are exceptions. A person may well lend another person some money because the second person is in difficulty. In every situation, it would be unreasonable to expect that borrowings can only be from banks. So A lends B money. B does not repay. A files for recovery. A obtains a decree for recovery of the money. Now B is a businessman. B sells goods to his buyers. Now some buyer of B has purchased from B goods on credit. Now that person owes B some money. Now when B files affidavit of assets, B can file and say that in my books of accounts, these are the amounts that are receivable from these persons. Now that is a debt, or those are debts owing to B, the judgment debtor. In his books, I have given on credit this material to that person on credit. The payment is due on that date. That's a debt owing to the judgment debtor. Now if that debt is attached in execution, then the court can issue a notice to that debtor. The person who has bought goods on credit from judgment debtor to be paid at a certain date or later, payment is outstanding. Court can issue a notice to that person and say, you come and pay that debt in court. Don't give it to me. You come and pay it in court. In this execution proceeding you pay. And I will issue you a receipt which would be a valid discharge against B. B cannot later say, you didn't pay me. The payment that is owing to B will stand satisfied on you paying to court, and I will apply that money in execution of the deed. This is what is called garnishing proceeding. Payment of debt by another to judgment debtor, confiscated and paid to degree holder. This is garnishing proceeding. Now from there we move on to execution can also be by attachment of salary. This is no problem at all. Partnership property or property of the corporation. Now business is done by many means. The law recognizes that a compendium of persons can join together and do business together in partnership. So, in the name of the partnership, they do business. So sometimes you can sue or be sued in the name of a partnership. The law recognizes, Order 30 in the Code of Civil Procedure recognizes partnership firms. So therefore, property of the partnership can also be liable to be attached in execution. If the partnership is judgment debtor, then its properties, all the partners of property of the partnership as held by the partners may become a subject matter of the execution to be attached and sold. So also corporation. Order 29 in the Code of Civil Procedure recognizes that corporations are a juristic entity. They can sue or be sued in their name. Appellant before the Supreme Court in that case was Shri Housing Finance Limited. That's a company. So it has filed a case in a court in its name. The company has what is known as a veil. Behind the corporate veil are the persons who are the company. You have the promoters of the company. You have the contributories to the capital of the company. You have the members of the company, the shareholders. All of them together form the company. Now the company has its own management through its directors. The directors meet and they take a resolution to authorize somebody to file a suit in the name of a company. So a company can be a person who can sue or be sued. So property, if a company can sue or be sued, it follows that the company will also own property. There are situations where the vehicles are bought in the name of the company because the person who is using the vehicle is the promoter of the company. He doesn't buy it in his name. He buys it in the name of the company. The government buys vehicles in the name of the department. So you see, these are all assets that belong to somebody and they may become attached or liable to be sold in execution. The Order 21 elaborately provides for all these situations. Then attachment of decrees is also possible in execution. A person may have a money decree, having had filed a suit against another person, say for rupees 10 lakhs, a person may be able to obtain a money decree for 10 lakhs. In that suit, the defendant is directed to pay the plaintiff sum of rupees 10 lakhs with or without interest. Interest, so far as the suit is concerned, there is the pre-suit interest period, there is the pendent likely interest period, and there is the post-future interest period. There are 3 periods. The first period, pre-suit period, interest, the calculation of the interest, you must remember as civil courts, is dependent on the Interest Act. There is an Interest Act. The Interest Act provides for calculation of interest and decree on interest up to the date of institution of the suit. From the date of institution of the suit until during the pendency of the suit is one period where section 34 in the code provides for interest. CPC section 34. The pendentility period between date of filing of the suit and till date of decree. Section 34 provides for the interest, the power of court to award interest. Section 35 is costs. 34 gives power of court to award interest, to decree interest. And then there is also the future interest, which is also provided for by section 34. You must remember that the Interest Act provides for court's power to grant interest up to the date of initiation of the proceeding. And in doing that, the Interest Act prohibits grant of interest on interest. So you have a cause of action founded in money. That money was payable. A comes and says to court, 10 lakh rupees was payable to me as on 31st March 2021. The court decrees the suit in August 2022. Now, plaintiff in his suit says that the goods I have sold or the money I have lent became payable at the principal sum 2.5 years before I filed the suit. 3 years is limitation. 2.5 years before the debt crystallized and was owing to me. And he did not pay me for all this period. So interest at the rate of banking rate of interest on commercial transactions. You apply and give me interest on the sum from the date he was supposed to pay me till the date of suit. This the court can grant under the Interest Act, under the provisions of the Interest Act. No interest on interest, no compound interest. Interest on interest is simply compound interest. What is interest on interest? Some interest accrues from, say, January to March in one quarter. The bank takes that interest and adds it to the principal. Next quarter, starting from April till June, the bank calculates interest on the principal and the interest for that preceding quarter. Compound interest, interest on interest. So in other words, Interest Act says court can only grant simple interest. You can't grant interest on interest, and this is up to the period of institution of the suit. Now, after the institution of the suit, the court may say that with the principal, this is the amount of interest as on date of filing of the suit. So it becomes 10 lakhs plus, say, 50,000. Court may grant pendentility interest and future interest on the principal and interest. That is possible. But that far you do not have to think, I am just giving you the concept. So where there is a decree for payment of money, that decree becomes then an instrument to obtain money from another. So, in lieu of paying cash, a person may trade his decree. I owe you this much money, I have a decree for that sum or I have a decree for this sum. That part you take the decree and the other part I am paying you cash. So a decree can be given to another person and that other person can file for execution. This is the rule. Where judgment debtor has a decree either for payment, attachment of decrees is also possible in execution where judgment debtor has a decree either for payment of money or for sale in enforcement of mortgage or charge as provided by Rule 53. I have given you the rule. Have a look at it and try and understand it if it comes to you in a court case that far, where somebody has taken a decree for someone else, from someone else. Let us look at 53. attachment of decrees. Where the property to be attached is a decree, either for the payment of money or for sale in enforcement of a mortgage or charge, the attachment shall be made. You see if the provision is there. So a decree can also be a property in execution to be attached. That's the whole point. Alright. Then point number 15, where property is to be sold in execution, there must be proclamation of sale of the property as provided inter alia by Rule 66. A proper procedure of sale must be followed by court because court is dealing with someone else's property. And if there is irregularity, it will expose the property, the sale, to be set aside. Subsequent provisions in Rule 90 to 93 also provide for sale becoming absolute or to be set aside. Now, these sale provisions are there in Order 21. Last point I have noted is equitable modes of execution. Does anybody have any idea what is an equitable mode of execution? What can be? Because you see, decrees can also be for injunction. So, a decree for injunction, as we have seen, can also be enforced by attachment of property. So, in your experience at the bench, have you come across any other mode of execution in any other provision anywhere? Look at Rule 2A in Order 39. Similar provision. Because you as civil courts will have a situation where you passed an order and that has been violated. An interim order. You issue injunctions under Order 39, Rule 1 and 2. Now that the person who has obtained the order comes and complains to you that has been violated. What do? This is not a case for execution. It's only an interim order. So you have incorporated in the code 2A where you can enforce your own order. Execution is nothing but enforcement of orders. Decrees. Execution is in respect of decree. This is in respect of, and decrees can also be decrees for injunction. So this is your an order you have passed. When you become judges of the High Court, you will have. When you become judges of the High Court, you will have the power of contempt, issuing rule of contempt, taking cognizance of contempt. But what is that? You have contempt jurisdiction when you become, because Article 215 in the Constitution provides that the High Court can punish for contempt of itself. Contempt is another executing mode. Then again, if you I do not know, now there has been a bifurcation. Company matters have gone to the National Company Law Tribunal. It is no longer with the High Court. But in company matters also, in Companies Act, there is a provision for winding up of a company. If the company is unable to pay its debts, it is to be compulsorily wound up. Before, the proceeding used to be by the court. Now with the 2013 Act, the proceeding is to be before the National Company Law Tribunal. Now what is the situation? A person says, this company took goods from me and did not pay me. If it is unable to, it not being able to pay me means the company is in involved circumstances. It should be wound up. It is a threat. Wind it up. Now, if it is an admitted due, the court or the NCLT will provide opportunity to the company to pay or will direct winding up. If the company wants to carry on with its business and if it's an admitted due, what happens? The petitioning creditor gets his money. And getting money in pursuance of a claim is execution. So you see, there are these modes of execution apart from what is provided here. So there are other laws also have built-in mechanisms by which a person who wants enforcement of an order may get it. Execution is focused only on trying to get the execution. A consequence of a winding up action may be the winding up of the company because the company is really unable to pay. The net worth of the company has become negative. The money that the company owes is more than what the company earns. Those are situations. So it is not necessarily that the person who has made an application to wind up a company will always get the result of having the money paid. But there is a possibility. And if it is, that is why it's equitable. Alright. So this is as far as I have prepared this note for you, and I have asked the director to circulate copies. It may be of use to you. Now, you can ask me any questions you want to on execution or on anything else, whatever you think I may be able to answer. Because I'll share with you my experience of having gone to the National Judicial Academy in Bhopal. I used to think that these question-answer sessions are wholly unnecessary because it drags the proceeding. I'd rather be released and go around and move and see what is there in Bhopal instead of sitting and expecting that I should be asking questions. So I didn't not only I didn't ask questions myself, I told all the colleagues who were with me, the judges from the other high courts, that please refrain from asking any questions so that we can fold early. But questions there were, and a session that is to end at 4 o'clock, sometimes used to go till 5 o'clock. And I learned what is meant by being bored. So I hope I have not bored you. Yes? Any questions anybody has? On any subject? Yes.
Lordship, this is in respect of Rule 97,
Yes.
which talks about resistance or obstruction to possession of immovable property. Lordship has said that police force can be used. Lordship.
Yes.
Lordship, what in your opinion are the best practices that we can comply with so that we don't end up with another criminal case?
Yes. You see, 97 is where the decree holder goes and says, first you see what happens is there is a provision where if it's in respect of immovable property, the court directs the bailiff to go inspect and report. It's the recce thing. They go and see and come and thereafter the court will direct the bailiff to go and hand over the possession. That means in effect is that he will go to that immovable property and he will tell the person there, you get out and I have come to take this from you and give it to him. The thing is, when that situation happens, there is this person who is sitting in the property and says, no, I will not go out. The bailiff returns to court and reports that possession could not be handed over. The decree holder has cause to make an application under 97. Resistance has come to notice of court. He makes an application under 97. Now the court under 97 will then go to Rule 98 I have shown you. Rule 98, Rule 100. All these rules are there providing for the procedure as to how the court will proceed. The court, if it finds that the person who is resisting has raised a question regarding right, title and interest of the property, first thing for the court to do is to ascertain that the person who is in possession of the property and resisting is not a person claiming under parties to the suit. That's the first question you have to decide. If on that premise you are convinced that the person who is resisting cannot or does not come under either plaintiff or defendant or their representatives as a property sold to them during pendency of the suit, only then will you embark on the next stage as to what is your claim to title. So at the first stage only there should be elimination. Some link. A person cannot just fly into the property. There has to be some link with the owners of the property for the purpose of holding on to the property. Because you must remember, a suit filed for recovery of property attaches with it the obligation of court to always see whether the suit is barred or not by limitation. So a claim of adverse possession comes within or under a party to the suit if made before expiry of 12 years. So if a person says, I have been residing here and I have adversely and with hostility towards the real owner asserted my title, that can only be for a continuous uninterrupted period of 12 years, prescriptive if you want to create a right by adverse possession. But if the suit has been filed within the period of limitation for recovery of property, and that question stands decided in the suit, cannot be reopened here. So, first thing you have to see is, who is the party who is offering the resistance? Is the claim of that party, or is that party connected to parties in the suit or their representatives? Once you get an answer in the negative, the no, that person cannot be said to be, only then you are convinced that his claim to right, title and interest in respect of the property was not decided. Because he is not claiming under anybody in the suit. Then the next stage is you embark on that second stage of determining the right, title and interest. Otherwise, in the first case, where you find that he is linked to some person in the suit, you straight away throw out the application and direct police cell to throw him out and give him the possession. And you will find in the CPC, forms of orders are also there. So you will never be at a loss. The CPC is a very good piece of legislation. Forms of judgments, forms, including the plaint, form of a plaint, form of a written, everything is there. So look up the CPC. Whenever you have a doubt, go to the CPC. For removal of doubts, everything you will find, not only the provisions, the forms are also there. So what is the order I have to pass in execution? You will find the form. That is, I think, basically your question. What kind of order I will pass? You will find the forms there. Alright. Any other question? No, there may be a good question in spite of that, what I said about not asking questions. Yes, any other subject you have a doubt, you think you can have a discussion? In any other branch of law or anything? Because I think most of you do, there must be a lot of, there are land revenue cases that you do. No. Then the criminal law is there are a lot of criminal cases. But not as many, I should think, here in Sikkim, because people are better here. There's not so much animosity and enmity that leads to one doing something, some violence on the other. And things like theft and other things are there.
Worship, we have POCSO cases mostly. Protection of Children from Sexual Offences Act cases. And drugs related cases. We have our own local legislation, Sikkim Anti-Drugs Act.
Yes. There are two things. One is in the NDPS Act, you have section 37, which really acts as a bar in giving bail. Because unless the court is satisfied, I don't remember the exact wording, so unless the court is satisfied that the accused was not involved, only then the bail can be granted, or something like that is the provision.
That is reverse burden of proof.
Yes. No, it's not reverse burden of proof. You see, the case presented before you as the bail judge may be such that prima facie from the case diary you are satisfied that this person was not involved. Then you can enlarge that person on bail. Because what has happened? Say a vehicle is travelling down the road and at a check naka it is stopped and there is a lot of, say, ganja that is there in the vehicle and it is much above the commercial quantity, or it is of the commercial quantity. Then this becomes a cognizable offence. Immediately the vehicle and the persons who are in the vehicle are apprehended and they are put behind bars. Now somebody applies and says that I am not involved. Applies for bail and says that I am not involved. You have to look at that situation. And in that situation, if you really find that you are convinced that this person was not involved, then you can grant bail. Section 37 only tells you that you must have that satisfaction. Now, no court wants to take the responsibility of being satisfied at that stage. So therefore, bail is not granted. So section 37 has been looked upon as a bar to granting bail. But you must read the section. If you think that the provision in the section is such that you can comply with it and yet grant bail, go ahead and grant it. Because personal liberty should not be taken away of a person. Now, this is just a broad example I gave. This is how it happens. In vehicles, things are, these medicines that they have drug content that is defined in that act. Now, they may amount to a quantity which is commercial quantity. And that would require the police to put these people behind bars and seize whatever there is. Right? And so far as prevention of sexual offences is concerned, that act, what does it do? It really takes away the concept and defense of consent. Once you are adult, the person who is accused of rape may set up as his defense consent. But when the girl is under 18, that defense is also not available. So this is the difference between the IPC provision and that act. This is just society's way of protecting or preventing, trying to prevent a situation of physical intimacy by persons who are minors. That's the whole object. So therefore, consent is not available. Straight away you are presumed to be guilty of having forcibly done something. So this is the basic, as I understand it, this is the basic difference between that act and the rigors under the IPC. All right. Any other question? So you deal with a lot of POCSO cases. Actually, it's a difficult thing because you see, in nature there is no law. In nature, the male and the female, how they will go about getting together, there is no law. Man has created a lot of laws. We have the institution of marriage. You don't find it in the animal world. But they manage to regulate their society, and pretty happily. There are no apparent disputes in the animal world not having these laws. We have these laws because we are evolving. If you look at how we have evolved, because we have a mind, we have become otherwise very vulnerable and weak. If we take off our clothes, do you think we'll survive one night out in the open? That weak we have become. Because we have a mind. We made houses, and we made heaters, and we made air conditions, and we've got cars that can take us faster than the cheetah. Now, if a cheetah is running at full speed, 90 kilometers per hour, it goes and bangs against something, collides, crashes, it will not die. Because it's its own locomotion, it's its own speed. If you run as fast as you can and you go and hit a wall, you will not die. Because your speed is that much. So your body will be able to take care of a collision at the speed you can generate. But if you are in a car like Cyrus Mystery and you don't wear a seatbelt and the car is traveling at 150 kilometers per hour, you will die. Because we made our mind give us locomotion that we cannot physically achieve. You look at the animal world, they have their coat. They can be in winter, they can be in summer. They adapt. Americans go to fight a war in the desert, they adapt the surroundings to themselves. They have air-conditioned tanks and tents and this and that and the other. So you see, this is how it is. So we have all these laws. Question is, can the relationship between man and woman be regulated by law? Or is it to be regulated by literature? You see, the more you think, the more you can think. Yes? Any other questions? You've had enough of me. Let's call it a day. Sure.
End of today's session, I would now request the lead director to kindly propose the vote of thanks.
Now, we have come to the end of the program. I, on behalf of Sikkim Judicial Academy and on behalf of all learned judicial officers, I would like to offer sincere gratitude to His Lordship for conducting such wonderful session today. In fact, it gives me immense pleasure to acknowledge that the untiring deliberation which Lordship has made to all of us today. And I hope and expect that whatever deliberation made today would definitely help to all non-judicial officers, and they will definitely use the same while dealing cases of such natures in future. And I once again would like to offer my sincere gratitude on behalf of Sikkim Judicial Academy to His Lordship. And at the same time, my deep regards and sincere thanks to all non-judicial officers for being with us and making this two-day session very vibrant and successful by their remarkable participants. And lastly, I wish to acknowledge the hard work put in by all the staff of Sikkim Judicial Academy, GT, Enterprise Catering Services, and all the stakeholders of the state government who are involved in this program for their wonderful cooperation and support throughout the program. And I once again wish them to thank from my bottom of heart. And with these words now, with the permission of His Lordship, I would like to declare the end of today's session. Thank you.